Good evening, everybody. This is Omar Serrato with the Tilted Lawyer podcast. I'm joined by Lauren Neidigh. And we are, I'll tell you, Lauren, we haven't talked about this yet. But this opposition to the opposition is a doozy.
Well, I believe that I did text you 3 times tonight, and I said, "Is this actually as dumb as I think it is?" So,
no, it wasn't. It wasn't dumb at all. Was the point? Like when you texted me that, I was like driving home. I was like, "Yeah, that's stupid." And then I read it. And I was like, "Oh shit."
I don't know, man. I don't agree with a lot of it, but we'll see. Obviously,
I understand, but we're gonna break it down.
Knowledge than I do, but as far as a lot of that goes, I feel like my opinion is also really based in public opinion, obviously. So I look at that and I'm like, you just did yourself a huge disservice as far as like how you're gonna look to people who are reading this right now. But okay.
Right. Here's how I look at it. There's like 5 key issues that need to be decided. Number 1, the timeliness. Like, should she just be allowed to be awarded 47.1 fee shifting damages without proving malice, reasonableness of claim, all of that stuff? If you just look objectively at the policy under 47, like it's designed to kick litigation out at a very early stage. The problem with that is that it holds contingent 47.1 fee shifting provisions on whether or not she brought this with malice and whether or not she had a reasonable basis to do so. The main argument that she should prevail is because Lyman kicked out Baldoni's defamation claim under 12b-6, basically stating that they didn't allege enough to prove malice. And so the question then becomes, could Judge Lyman find as a matter of law, based on the dismissal without any evidence being presented, that there was no malice and that she had a reasonable basis? They have a strong argument to suggest that Lyman can, because he's already found that she didn't bring this with malice. Then the question becomes,
like, I'm looking at it like a lot of what they said that could maybe establish malice was shielded by the litigation privilege, which doesn't necessarily mean there was no malice there. It's just that they can't use that.
Right. But the problem also becomes like think of this as 2 different lawsuits. Like, we've been thinking about this as an amalgamation of legal issues, when really procedurally, these are 2 separate lawsuits. One of them failed and one of them still alive. And so whether or not she brought this maliciously, if they never brought a defamation claim, obviously 47.1 would not be invoked. But when Judge Lyman said that they did not plead enough to demonstrate malice, he basically shut down that issue forever. So there's no malice. There's no malice.
You know, I'm not psyched about that, but
the question is, okay, but what if, like, at trial, we somehow prove malice where there wasn't enough evidence available, because this is well before discovery had been exhausted. And so therefore, where we couldn't plead malice back then, we were able to prove it at trial. What do you say then? And that's kind of the big conundrum with this case, isn't it?
Well, they're saying that doesn't matter though, right? They're saying that you shouldn't have to wait until the trial to prove her like affirmative claims or to, try her affirmative claims, that they should right now award her these things. And then they're saying that it doesn't matter if there would be different outcomes. How does that not matter?
It doesn't matter because malice has already been proven by virtue of Lyman's ruling that she did not have malice. And by virtue of him making a finding, sort of, that the whatever defamatory statements were necessarily privileged when she filed her CRD, that gives rise to reasonable basis. That's basically their argument. That's why they're stating that they shouldn't have to be able to.
Are we sending the message that anybody who goes through the right channels, as long as you have the right connections and you do all this the right way, don't have an investigation or anything like that, anyone who goes through the right channels to protect themselves with litigation privilege can just cry harassment and then receive hundreds of millions of dollars in damages, even though they haven't actually provided any factual evidence to support their claims?
So I am not saying that.
No,
Matter
no,
of
no, no.
fact,
I'm just saying, generally speaking, is that the argument that's being presented here? Not you, dude. I'm not stupid.
okay, I'm just saying. No, because I am of the opinion that 47.1 should not be applied until all of the litigation is done. All of it.
That's the only thing that makes sense. Like, I
They're
don't
trying to
understand
treat it as like two separate legal issues, which they kind of technically are. But like he made his decision to drop. Well, I guess not really. His defamation lawsuit was thrown out at 12b6. Therefore, he was never going to be able. The malice issue was dead. The question is whether or not the reasonable basis issue was also decided as a matter of law when Lyman did that. Wayfarer is saying obviously not, because
No, I think it's a bunch of bullshit. But
matter of fact, she's a liar. That's basically what they're saying. And then Lively is saying that no, this was privileged. There was nothing in their pled complaint for defamation. There was nothing in there. No defamatory statement that would have occurred outside of the CRD. Therefore,
Right.
privilege. Therefore, reasonable basis. Therefore, fuck off. We don't got to prove anything. That's what they're saying.
That's so fucked up, though.
But hold on, we're at the very beginning of the analysis, right? Because we're gonna go.
Yeah,
We still
I
got to get to
understand. It's just, like,
extraterritoriality and all that.
but here's what I'm saying. Like, as much as we kind of analyze this stuff and read all this stuff, and like the thousands of people who've been watching this, like there are outlets like TMZ and fucking Us Weekly and stuff where one of them is going to get to it first. They're going to read like 3 paragraphs of the introduction. They're going to
Yeah.
go off of that. And then the others are going to copy and paste that shit, change a few words, and then count it as journalism. And so that's
Nah.
what's going to be passed as. And I feel like that's not what this is.
No, well, first of all, nobody's gonna TMZ and all these media outlets are not gonna get this correct. I'm just
No.
letting you know, full stop, that they're not going to understand why whatever ruling is made is going to be made, because this shit runs deep. Like this is not a lightweight issue. Number one, we have no instructions from the courts. It's a case of first impression. First, let's get rid of, like, there was some suggestion that because this is a case of first impression, this federal court should not be the one to set precedent, which is nonsense. This is a federal court sitting in diversity. And if 47.1 is implicated and they have to decide it, doesn't matter if they have some instructions on how to do that. If they got to set precedent, that's what they got to do. And so that argument is nonsense. That was Wayfair's stupidest argument. The second thing is, should they be awarded 47.1 absent certain factual findings? Because it's true. Now, look, the first requirement to getting protection under 47.1 is that you brought a complaint or that you prevailed in the defamation lawsuit, right? And she did. 12b6, defamation was kicked out. There's no doubt about it. She was the prevailing party, right? But then they attached to it these evidentiary requirements. It's conditioned on, it's predicated on the assumption that the sexual harassment claims were not brought with malice and there was a reasonable basis to do so. So then the question becomes, okay, so since this was kicked out with 12b6 and the judge specifically said there was no malice and it was privileged communications, therefore we shouldn't have to be forced to prove anything. And the legislative intent appears to be written in such a way that we're trying to protect people who bring these claims early on in the litigation, so they're not in a Tyler Perry situation where this kid, maybe he prevails in defamation, but now he's going to be in litigation for the next 2 years against a billionaire sitting there with his $50,000 from his inheritance or whatever, trying to litigate against Tyler Perry. That's what it's designed to do. And in that scenario, you want to get rid of the litigation at the earliest possible opportunity. That's what 47.1
you want to help the regular people who can't afford that shit against people who are actually abusing the process.
Yeah.
And so that's what sucks so much, is I'm looking at this and I want to criticize it to death, but at the same time, I'm thinking in the back of my mind, I'm like, what am I really, like, what kind of damage are we really doing if we were to, like, take this away? You know what I mean? So
do you remember specifically if this is correct? Julie Baby says that the only thing Lyman ruled on about malice is with New York Times. I'm pretty sure that he said that there wasn't enough to prove malice and therefore defamation claims were going to fall short. Am I remembering that wrong?
I don't want to misspeak, so I'm going to tell you right now I can't. If mods, one of you can look that up for us.
So Julie, if I'm wrong, if I'm wrong on that, I apologize. I thought I remember him saying something like that with respect to malice and defamation. I remember it being a big deal, and maybe I'm just misremembering because it was like months ago.
It was
Um,
yeah, solid 3 months ago, 3 and a
but if
half.
that's the case, then they can't argue that the malice issue has been decided because it wasn't litigated on, because it was dismissed. I feel like Lyman specifically said malice is dead. I mean, obviously I'm paraphrasing, but he said something to that effect.
Why
Like, it's
not
been
you go ahead and talk some more about this while I look that up. How about that?
certainly, yeah, look it up. Um, I hate when you do that to me because then I'm like, oh, what were we talking about again? Um, so, so that's one aspect of it that you have to decide, whether or not, at what portion do we start applying 47.1? Okay, so if she's prevailing party, there's no doubt about that. This federal court, it doesn't matter if they're setting precedent, they have the ability to make decisions. They have to make decisions. Um, the main question that we all had, like really from the beginning, is that they have to prove, or there has to be a finding, whether or not it's proven or not, there has to be a finding that Lively's claims lacked malice and were made with reasonableness. Those were not actually adjudicated if they were dismissed on a 12b6. And it might be the case that Baldoni, in his defense of the SH claims, had this expectation that he was going to be able to ferret that out in the course of a trial, and to make a 47.1 ruling now strips him of that ability to do that. And they were talking about a lot of other stuff about the parallels between this and prosecutorial misconduct, about how the issue there is like probable cause. And probable cause is largely an issue decided by a judge, not by a jury. And then they started making all these other parallels. Is like, usually when there's not really much dispute about the facts, then the judge gets to decide the legal conclusions about where those facts lead. I'm not so sure that we have a full-on agreement on factual stuff that happened, which would suggest that maybe we should wait until the end of the trial to make a finding of certain things. And so, I don't know. It's not the worst argument to suggest that Lively should not be forced to have to plead anything because it's already been decided, because these were privileged communications and they failed to plead malice. Therefore, dead issues. 47.1 should apply. What are we waiting for? So there's one thing. Lauren, you still there? Did you find anything?
I'm here, but this docket is ridiculous, so I'm almost there.
Well, that doesn't help.
Oh, I'm not trying to be helpful. I'm sorry.
The other issue.
Give me, if anybody has a docket number, help me out here. But otherwise, I'm digging.
All right. The third issue that had to be decided was whether or not punitive damages or treble damages could be decided at this early stage. There's certainly going to be a requirement. She's going to have to prove some damages to get treble damages, and punitive damages is usually something that's decided by a jury. So that's problematic. And so I can see a court, or I could see Judge Lyman saying that, yeah, 47.1 applies, but you're going to have to independently prove up damages. And Lively made that argument. Yeah, we can have like a separate hearing for damages. We'll prove compensatory damages. We can prove actual damages, whatever we got to do to make a finding or a calculation for treble damages or whatever. Maybe they could get a jury in there to decide punitive damages, but that would be it. That's one way that they could go about deciding it. But there's no getting around. Lively's going to have to prove harm. She's going to have to prove permissibility of a punitive award based on the facts, some factual findings. Whether or not 47.1 applies now or later, at some point, and maybe not right away, maybe not even, it might be after the trial, I don't know. But she's going to have to prove damages at some point. If this is going to trial, then I guess this would be sort of like a miniature trial within the trial to determine 47.1's application to the case. In which case, just logically, if we're going to end up doing that anyway, because there's no sign that Baldoni's going away, he's not going to settle on this case. He's going to demand they go to jury trial. And if they're going to go to jury trial, we're going to litigate the facts, and we're going to get facts that necessarily speak to malice and reasonableness of claims, then what are we doing? Why would we apply 47.1 right now? Why? And so that would be an argument in favor of applying it later. But what I can see, oh, this one is breaking my brain, because I could see a world where Lyman literally says, yeah, 47.1 applies, but we're going to wait to assess or calculate damages till the end of the trial. And then once we get to trial, I know. And I apologize for being all over the place, but I'm just spitballing in my head the arguments that Lively's legal team made, because these are like this is the problem with the statute. Like it ties to it. It ties to recovery of these fee-shifting provisions, factual findings. And they're saying that the factual findings that they're required to prove were decided when Baldoni lost the 12b6. But he's not going anywhere for trial, and so we're going to have a trial anyway. And so I get it. It's like we have lawsuit A, lawsuit B, right? Because we had the complaint, then we had the cross complaint. Cross complaint is dead. The complaint remains. We got these two separate little trials, and now there's only one. We're going to have a defense. Baldoni's going to lodge a defense. And in that case, we're going to have more information factually about how to apply reasonableness and malice. And it might just come to pass, and it wouldn't be the first time that a party was not able to plead something months ago, and then we get to trial, and then facts materialize that suggest malice and unreasonableness when we get in front of a jury. That wouldn't be the first time that happened. And it would make all the sense in the world for the judge to just take control of it and say that, look, first of all, I say all of these things, and I apologize if I'm rambling, but here's what I'm thinking. 47.1 is not going anywhere. There is no instructions whatsoever on, there's not a rule that says we have to apply it at the earliest possible scenario. There's no rule that says we have to apply it before trial. And if there's factual tie-ins that are tied into collecting under 47.1, then why wouldn't we wait if there's going to be a trial where there's cross-referencing facts? Why would we not just wait till the conclusion of the trial to make a determination of everything? Like once we've determined guilt or innocence as to all the causes of action, then go into a discussion about damages, and then decide whether or not 47.1 applies based on all of the information. Why wouldn't we do that? If 47.1 is not imploring the Second Circuit to rule at the very second that Lively prevails in her against the defamation claim, then why do it now? For what?
Do you see the screen at the bottom?
No, I'm not looking at the screen.
No. You know where my little thing is, where you put me on the stage?
Oh, at the stage? Yes.
Next to it, there should be. Okay. So let me pull into this a little bit. All I pulled up was like references to 47.1, right? Because I don't know what else to look here except for malice, and there's like a bunch of words there. So
how about just do a Control F malice?
No, I did that, but I'm saying there's like so many references to that.
Oh,
that
okay.
I just we're not getting through that tonight.
Court denies motions without prejudice to renew in accordance to the ruling here. Court has not ruled on whether Lively's statements were. So we don't know if they're privileged or not. So if we don't know that they're all privileged, then there's no basis for Lively to claim that she shouldn't have to prove reasonableness.
Okay. I think maybe that's what people were saying. Hopefully we got that right. And like I said, there's a ton of references to malice, so like I can look it up here, but there's just so much. Like I'm not.
You guys, I really apologize if I'm a little all over the place. I literally just read this like 20 minutes ago, and so I'm just like processing all of this in real time. And I'm arguing against
I bitched
myself.
about it for 30 minutes, and then I was playing Fortnite. So I don't know. I don't know, dude. I didn't do any research between then and now. So
yeah. No, I'm letting this process. I'm letting it sink in just for my own, conclusion that relevant statements were made without actual malice. In addition, the Wayfarer parties do not identify any particular factual allegations that could be added to support the defamation or civil extortion claims, nor is it plausible that any allegations not yet mentioned would change the basic substance of Lively's threats, the conclusion that the CRD complaint was privileged, or the conclusion that relevant statements were made without actual malice. In addition to their 224-page amended complaint, the Wayfarer parties have already submitted to this court an additional 168-page exhibit with additional details relevant to their claims. Although the exhibit is not properly considered for purposes of the motion to dismiss, the allegations within it still will not allow the Wayfarer parties to state a claim. Show me where there was a finding that they did not plead malice.
Somebody said page 90 on the footnote. Hang on.
The Wayfarer parties argue based on 270, 17 pages. The paragraph does not purport to report on particular actions or statement generally characterized motivations, concludes K. Domains, letter claims. Paragraph does not put lively on notice that the Wayfarer parties could make, because the court holds that any plausibly alleged allegations to the times where privilege under litigation and fair report privileges, it need not consider whether they fall under the sexual harassment privilege or were made with action. So they haven't decided malice then. If I read this paragraph correctly, it sounds like they haven't decided either of those things.
Okay.
So did I wow, I remembered that wrong. How embarrassing.
Well, I mean, to be fair, it is in a footnote. So it's like, how were you supposed to remember all that? Because I didn't remember either. And I read this shit to death and I didn't remember that. So
I just thought that they had, I don't know, if somebody could point to something else that says specifically malice is gone.
Well,
please,
if anybody can do it, I'm sure they're right here with us and they're going to tell us in a second. So let's not waste too much time trying to find it on our own because everybody else knows this shit.
So here's my general takeaway, just processing.
You can take that off the screen, by the way, if you want. Oh, I can do it. Yeah.
If there hasn't been an official determination that malice was there or not there, or reasonableness was a thing or not a thing, then Lively shouldn't be able to make the claim that she shouldn't have to prove anything. Because it's multi-pronged. She has to prevail on the defamation claim. Good for her. You got that one. Then she has to prove that she didn't do it with...
Clap again?
No, I was clapping. I gave her a golf clap. Then she has to prove that she didn't bring this with malice under the legal standard of malice. And then she has to prove that she was reasonable in her claims. Does that mean that if all of her potentially defamatory statements would have fell under litigation privilege, that it would be deemed reasonable? There's courts that have said similar things to that for sure. But if we're interpreting reasonable to be like a subjective standard, then maybe she shouldn't have to prove anything, because you could have a ridiculous subjective thermometer for SH claims and, bring Lively style SH claims. Or are we saying that reasonableness must be determined by the reasonable person standard, by not on either end of the extreme, but what the average person would determine a sexual harassment allegation is? And then I feel like that has to be put into context. Like if we get to trial and we just figure out that she lied about everything, then no, I feel like if we prove that she lied, that should be referenced with respect to malice. It should matter with respect to reasonableness, and it should disregard 47.1's application.
I'm still just very hung up on the fact that this law is being tested on a parasite and designer clothes. Like I cannot fucking deal with this.
Elaine says they failed to successfully plead malice for RR, LS, and the New York Times. That's what it was. You know what? I think that's right. That's what it was. How come I can't read this comment? Oh, the judge didn't even determine for BL because he dismissed claims versus her because of litigation privilege. I could tell you that Lively's interpreting because her statements were privileged, therefore reasonable, protected. Therefore, by virtue of her filing the CRD, the reasonableness standard is met. I don't know, man. I'm worried about it because I can see a world where a lineman says, yeah, they didn't prove malice. They didn't disprove reasonableness.
Well, look, I can tell you right now what people are going to worry about, whether or not that's going to happen or not. What people are going to worry about is that if there is a reasonable scenario where Judge Lyman could do that, they're going to say that he's going to do it. So I think that
I'm telling you right now there is. I'm telling you right now there is.
Yeah. So, well, I mean, everybody has a very, set in stone kind of mindset. that Judge Lyman is always going to rule in Blake's favor. So I think that's
Yeah.
why we're getting such a visceral reaction to this right now. Because
I'm
there's
worried,
so much on the line here, I feel like, just implication wise. So it's like, I don't want to believe that, but at the same time, it's kind of, I've seen the pattern here, and I don't believe that it's necessarily a matter of like the judge being paid by Hollywood or anything like that. But I see a pattern here, and I feel like she is pretty much getting her way with most things, and it's unfortunate.
So I'm of two minds. I could see a world where Lyman just says, yeah, whatever, 47-1 applies.
Yeah, that's a big
that at
whatever,
trial.
though. I feel like it's a big whatever. I would not do that. Like, well, holy fuck.
I mean, he could do that and then just like make it contingent on them proving damages, which would necessitate. I mean, we're going to trial anyway, so why don't we just hold the damages hearing till after the trial so that we're not compounding litigation?
Right.
I think that he satisfies the legislative intent of 47.1 by saying, yeah, 47.1 applies, but you're going to have to prove damages, and that's going to be necessarily after the trial because we're not going to hold two hearings or two miniature trials on the issue of damages.
Yeah. Okay.
I could see him doing that. But then we didn't even get into at the extra. This is what had me all riled up. The extraterritorial stuff. Way back when, you remember when the Wayfair parties decided that California law applies.
I was very confused about that, actually. So that's what I still don't understand to this day. I was kind of like the back and forth on that between New York and California. I was like, I don't fucking understand this because I've never seen a federal case. So
that is not a stupid argument because it goes like this. If the Wayfair parties did not agree to California law and Lively just invoked it because she wanted protections under 47.1, then no effing chance that 47.1 would apply because of the extraterritoriality of it all. It doesn't have that kind of language and it would not apply. But what if the parties agree that California law applies? Well, shit. If that's the case, then why shouldn't 47.1 be invoked? If both parties have decided that California law applies at a very early time in the litigation, just because one statute in California is more beneficial to the other, it shouldn't matter. Both parties agreed California law applies. Those are the rules we're playing under, and a court in diversity should honor it. I don't see how you defeat that argument.
They both agree that California law applies, but they don't both agree on whether or not this law in particular is constitutional, and whether or not she should have to prove that her claims were brought in good faith before she gets paid. So I don't know.
Well, what I'm saying is I was pretty confident yesterday when I was on with Cassidy about these extraterritorial divisions, and then I forgot that, oh shit, they did agree to California law. Oh no. They did agree to it.
Yeah. So here's my problem. I'm hung up on these two things from like a moral virtue standpoint. And so like you're obviously gonna have a harder time getting through to me where I'm like, I don't think that matters as much because whether or not it does or not is irrelevant to me because my whole thing is like, this is my moral indignation that I'm talking about here. I don't know the law. Okay. So I think that you should probably like talk to Rachel or talk to Ask Two Lawyers or talk to somebody who
no,
really
I will talk to you because it's like a situation where like I'm with a client and I just had fuck moment.
Yeah, I'm just oh my god.
Look, it's not we're not losing the case on these grounds. It just means it's something that
yeah, to me it's not necessarily whether or not they lose their case. I think eventually like he will be vindicated when she cannot show any evidence of sexual harassment at trial. That's what I firmly believe. And so I think it's going to eventually work out in his favor, even though the path to get there might be very rocky. But I am concerned about the implications this has for regular people in the meantime, regular people who need these laws to protect them, regular people who need these laws in place so that they can get justice at all and not demand hundreds of millions of dollars from somebody who pissed them off because what? Because in my opinion, he didn't want to have an affair with her. That's not his fucking problem. So I don't know.
It's really shitty that 47.1 is being tested like on the other side of the extreme for somebody that's not a victim. You know what I mean? There's significant flaws in 47.1's logic, and I think we're seeing it. And it really just matters with the application. Here's what I'm relying on. I am hoping that Judge Lyman just looks at this logically and decides that, look, I can't even apply 47.1 until you prove damages anyway. So I'm just going to forego making a ruling on it until after trial, unless somebody tells me that the trial's not happening. That way I could, if I'm the judge, this is what I would say. All these things are true. Yes, 47.1 should apply. Maybe malice could be kicked out now because of 12b6. Maybe reasonableness should apply because these communications were privileged. Maybe. But as far as I'm concerned, we're still going to trial on cross issues that are going to give me information that I don't have now. And there's nothing in 47.1 that requires me to apply it now. If you told me tomorrow that you were going to settle this case, we're not going to have a trial, and we're just going to do 47.1 damages for settlement purposes, then I would apply it and I would rule that it applies based off of that. But if we're going to have a trial on cross issues of facts, then I'm just going to wait because there's no reason not to. And I feel like I do better. Nobody's going to be prejudiced if I have more information. Lively is not going to be prejudiced or saved from litigation because she's still going forward with these sexual harassment complaints.
Right.
As far as I know, and Baldoni has asserted a defense and he's entitled to defend himself. And so I have no obligation to make a decision on this now. I'm going to wait. How about that?
Yeah.
If you don't like it, write a writ. File a writ.
Write a what?
File a writ and appeal. Appeal me then.
Sorry. I thought you meant like Ritz crackers. I was like, Omar? What are you talking about?
Hold on, we got some ABF 959. I doubt that Lyman or any judge would risk the likelihood that a decision on this motion could be appealed. I don't know. Lyman's been appealed a lot, so I heard.
Yeah.
But gosh, if I was a judge, I would not want to be like, if there's nobody forcing me to make a decision now, why would I do it now? I guess the one policy argument would be that, look, maybe if Lively knew that she was prevailing under 47.1 as the victorious defendant in a defamation claim, that would necessarily allow her to dismiss her sexual harassment complaints. But there's no guarantee with that because maybe Baldoni wants to defend and doesn't let her dismiss. So that doesn't really work. So then F it. Let's just do the trial. Yeah. I'll decide once the litigation is over. There's nothing requiring me to make a ruling now. And if the California legislature doesn't like it, then fix your freaking statute. How about that? Amend it. Yeah. To force me to do something earlier. Because there's problems because it's a first impression. I'm not going to have the absurd results of 47.1 being tied to factual findings where this court hasn't seen any evidence and be forced to make rulings as a matter of law when I don't have to. As far as I could tell, Lyman did not rule out malice, and he did not say that her claims were necessarily reasonable.
The thing that I keep thinking about as we're talking about this more and more, the 47.1, the first impression thing, I really think this is all for notoriety. I really think this is all about her being some sort of face for the Me Too movement, the next wave of the Me Too movement. I really think that she wants that brand. And I hope to God it doesn't work because she does not deserve it.
Well, I think that's what's going to happen. I think that if she prevails on this 47.1 argument, I think that she's going to try to dismiss the SH and declare herself the victor.
Yeah.
That's what she's going to do. That's what she's trying to do right now. So if I'm the judge, I find that to be an absurd outcome. I see no reason to do that. If there's not a statutory provision forcing me to make a decision now, I'm not going to do it. That's just.
She took these text messages between Justin and Melissa Nathan in her tonight in this pleading, or not this pleading, but this reply. And she said this message between them that says, we think she believes what she's saying. She actually believes that's true. And she says, well, then, like, they knew that we weren't acting with, any sort of malice or whatever. But those were just two people who were clearly venting in context, clearly venting about how we actually think this lady is fucking psychotic.
So I guess that kind of goes to my point about it depends on how 47.1 contemplates reasonableness.
Right.
If they decide that you had a reasonable basis to bring a claim, and you could find reasonableness where you're basing it off of privileged communications, then I guess she wins. But if you're saying that reasonableness is held to the reasonable person standard of what constitutes sexual harassment or not, that's something different. Because if she subjectively believes something, but she is misconstruing the facts and is way out of line, and that's not going to amount to sexual harassment, that's the legal standard for sexual harassment for her claims. It just depends on how 47.1 interprets reasonableness, and I'm not exactly sure on that.
I actually kind of find it interesting also in that context that she dismissed her distress claims, except for the garden variety, whatever. She dismissed her emotional distress claims because she didn't want to give up her records from therapy or psychiatry or anything that could really prove her distress. And I'm thinking, like, in my mind at this point, and I'm looking at the text message she cited tonight, and it comes back to mind that I'm like, I wonder if your therapist or your psychiatrist said to you, hey, this doesn't make a lot of sense. Maybe we need to talk about this. Maybe you're not really seeing things very clearly. So,
but wasn't there like a ruling made in discovery that stated that they could still go into issues of emotional distress?
Garden variety, yes, but not they cannot ask for her medical records. Like, they can't demand her medical records. So that's why she dropped those claims.
By the way, you got a couple super chats. I think you're gonna want to.
Neat.
This one is you, Shenanos.
I thought Wayfair just wanted CA law for their lawsuit against New York Times because that is where damage most felt. I remember they did initially file against the New York Times in California, yeah, but then they eventually just combined that with the New York case, so I'm not really sure. They never actually served the New York Times, so they filed the lawsuit, but they were never actually served in California, so that was the weird thing about that. Yeah. I don't really know. I mean, that could be in the beginning. I don't know. But like I said, I think that they never really served them there. So it just kind of went by the wayside, I guess. So.
If their assent to California law was limited to New York Times, then they're going to have to argue that and convince Judge Lyman, because it makes all the sense in the world to me that when two parties decide to apply a certain state's law, then you should apply it. Yeah. But that would be one way to wiggle out of it, I guess. But yeah, it's problematic that very early on, I just don't remember specifically what they said. And I'm not about to like look through thousands of pages of pleadings. Find it right now.
Not tonight, no. I'll probably do that shit later. But.
Yeah, you got another one here. Big Z.
Big Z, thank you for the 10. Imagine having to pay 3 times damages plus punitive, etc. for 1, doing your job, acting, 2, showing a still of a birth video, exactly, and 3, saying your co-star's outfit is sexy to reassure your co-star who's deeply insecure. That's correct. She said that she wanted the outfit to look sexy. And so when he says, she was very insecure about that. And so when he said, this looks sexy, this outfit this way looks sexy, she was like, oh, that's sexual harassment. Like, what the fuck? That's what you said you wanted.
That's what I'm stating. What does 47.1 mean by reasonable? Does that mean that, because look, does that mean that the alleged conduct reasonably constitutes sexual harassment?
Yeah.
Because I don't know. Man. I don't know.
Yeah.
I got to think about that one. You got another one here. AC35.
Hey, thank you for the 8. Please read Mechan's comment above. I'm trying to find it. I'm not sure how far above your comment it was.
I'll find somebody named Mechan. Mechanic? Is it Mechan?
I saw that one, so maybe that's what they meant. Mechan Tech.
At no point did Wayfair agree California law apply to Blake's claims. Yeah, that's a distinction, isn't it? Because if that's the case, choice law is not just for all claims with multiple. Yeah, well, just out of 100% transparency, I have no idea. The constraints
the one
of the
above their comment, though. So there was another one here. Trying to find it.
I like it better when you control the comments.
We'll do that next time. Somebody says, okay, so I think it's the same person, says the 29th defense says plaintiffs. The 29th defense says plaintiff's claims based upon California statutes are barred because plaintiff does not allege that defendant took any wrongful actions within the state of California. Is that the one we're looking at?
No, I'm looking at this one that's on the screen right now. It says, Omar, they didn't agree.
Yeah.
They said California for their claims because they're California residents and cited case law stating the choice of law for defamation is based on where harm is most felt. Yeah, they're going to, I feel like a reply to the reply is needed and they should file it like tomorrow. They got to address that because I think that really matters. Because if their California agreement was nuanced in that way, then we should decide that. In other words, if they had no intention of stating that, yeah, 47.1 should apply to her SH claims, it only applies to these claims because of jurisdictional issues, that's different than saying that it should apply across the board. And that might save them. It might. All
right.
Once again, I apologize for being all over the place. I'm just, I'm a little frazzled. I'm trying to process all this like right at the last minute. I think I texted you thinking this was going to be like a lightweight, 30-minute stream. And then I started reading things like, holy shit. Oh, shit.
All right. Somebody's pointing me to 211 on the Second Amendment complaints. I'm going to look it up real quick.
Okay. Look that up. And I'm going to read more of these. Oh, that was AC 35s. Hey, read Metchin's comment. Big C says she only wants that brand because it's in her interest now. It forwards her agenda currently. She didn't care when she was promoting the film about defeat. I mean, I believe that 100%. I do. And then we got to this one before. Yeah. Did we cover all of the issues yet? Let's see what else is here. I'm reading through the motion. There was just like the policy arguments, which, yesterday we were reading this case, Royal Dutch Petroleum, that gives that mic drop line. When a statute gives no clear indication of an extraterritorial application, then it has none. And then I said that, holy shit, that's pretty much game over right there. It's true. I guess unless, and what they're rolling with is, no. They agreed to California law. You can't just change it now because of 47.1. That's what had me shook. Here, Wayfair, they're shit.
I pulled up the thing. Hold on, sorry, that they told me to pull up. But also, somebody here said they were going to see Omid. Big Z, please tell Omid I said hi and give him a hug from me.
Omid?
Yeah, Omid's a comedian. He's a friend.
Oh.
Yeah. So anyways, here's the footnote that they asked us to pull up next. So can you pull up the screen again? You know where it says share at the bottom?
Yes, I can.
Okay. So they said to pull up this footnote at the bottom of 211, and this is the amended complaint by Baldoni. It says, Lively has contended that California law applies to any dispute involving the Wayfair parties or the film, without conceding that Lively's statutory claims are properly brought, and with reservation of all rights and remedies, the Wayfair parties assert their claims under the substantive laws of the state of California. What does that mean?
Well, it just means that we're not saying that Lively's claims should be ruled under California law. We're saying our claims should be ruled under California law. It just, their claims as to who. If it's as to the New York Times and not to Lively,
right, that's
different than saying that, yeah, our California claims against Lively should win and Lively's California claims should lose. That's absurd.
Okay.
So that's a nuanced conversation that we still need more information for. What specifically were their California claims? Refresh my recollection.
What's up?
What were their specific California claims and who were they against?
I would love to tell you, dude. But it's been 7 months. So I have to look over this stuff.
Well, we're gonna have to discuss that.
I mean, this just came out a few hours ago, guys. So just bear with us. We're doing the best we can, but like we're gonna have to look over a lot of this stuff before we can really do an in-depth, I guess, kind of.
Yo, normally I would spend like a couple of days with this before I jumped on here and started
Yeah,
rambling, but
yeah.
tonight I thought I just underestimated the breadth of this, and so here
All
we
right.
are.
Yeah.
Seashells Bell says the loan out agreement has California governing law. The loan out agreement.
Hmm.
Is that like an employment law claim though?
I don't know.
If it's employment law claim, then they still might be okay.
Well, so
I
some
don't
of
know,
this,
dude.
some of this stuff is like the reason I get so confused. Also, is some of this stuff is kind of separate. Like it's not a separate lawsuit. I guess it's a related lawsuit with Stephanie Jones and Jennifer Abel, and so I get confused by some of that stuff.
So they're conflating the two. We're just going to have to build a litigation map and decide who's agreed to what claims and to where.
Yeah. Okay.
Oh, somebody said, ah, shit. I lost the comment.
What was it about?
I don't know. Something good. Oh, I remember that the California claims were why Ask Two lawyers thought Wayfarer was screwed as for 47.1.
Okay.
Was that because those claims were related to Lively, though? That I don't know.
Well, I'm going to message them and ask them about that.
Yeah. Now should be the time where they like jump back in after like 2 months of being gone.
Yeah, I haven't seen any of it. So
this is I'm telling you, man, this would be the one.
Yeah, definitely.
Oh, I hate hearing my voice. Never do that again.
What? Who are you even talking to right now?
I just heard an echo of my voice and I didn't like it.
I think it was your fault, man.
Yeah. So the last thing was constitutional considerations, and I don't know, the Nora Pennington stuff. They made some arguments there. I'm less convinced that the constitutional arguments are going to be the reason why this is going to get thrown out. I just don't see this judge deciding that 47.1 is unconstitutional, so I'm throwing it out. I just don't see that.
I mean, it's a lot of pressure too.
Yeah, basically, it doesn't violate First Amendment as long as it's, because this is going to be the argument. If 47.1 is only supposed to apply to protected claims that are brought without malice, that are reasonable, then it's necessarily not baseless or frivolous, which means that we could punish it without running afoul of the Constitution. That's the argument. And when you frame it that way, it's difficult really to argue against that. But if we decide to litigate it now without them having to prove anything factually and just stating that, well, because of this 12b6 dismissal, we've proven our claims as a matter of law. We don't have to provide any proof whatsoever. 47.1 should apply. That's where I think it runs afoul of constitutional principles because of fundamental rights of due process. And that's where I fall on it, and that's where I'm going to die with it for tonight. I don't know, man. Yeah. I don't know.
I mean, we definitely did the best that we could with the information we had. So, there's a lot to. If you want to go over this again, we have to prepare for it. I feel like.
No, I'm gonna have to sit with this some more and really figure out. Because when I got to see what specific. Here's what I think. If it's not true that the Wayfarer parties did not concede to California law with respect to Lively's claims and only decided that California should apply for some separate claim to some other party, then I think that extraterritorial or the absence thereof of those provisions should control, and that 47.1 should not apply, and that consequently all of the FEHA claims should be kicked out, and some of the Title VII stuff, and some of the 52.1 stuff, all of those things. I really got to look at that language and decide what's going to happen with that. So I got to be honest, man. I'm at a loss, but admittedly, I'm at a loss because I feel like Lively has an opening to produce an absurd result. And I got to tell you, I don't have any confidence that Judge Lyman is the kind of judge that is going to exercise patience and common sense in the face of a case of first precedent.
Yikes.
Leaving it in his effing hands is kind of scary. But I feel like a prudent judge, knowing that he has no, that there's no need to hurry, would decide to wait a little bit.
Yeah,
it's like John Wooden said. It's like the famous saying: "Be quick, but don't hurry." There's no reason to hurry this decision.
Yeah,
and we got trial coming up in 4 months. What are we doing?
It's 5.5, I think.
Whatever. It's less than 6 months. We got trial in March.
I need it to be more than 4 months because I'm going out there, so I got to figure that shit out.
Anyway, my brain really hurts. I think we should dip out for tonight.
Yeah, it's 110 here, dude. I'm fried.
I am sleep deprived. I'm exhausted, and this case.
I think we might have missed one more chat there.
Oh, a couple of them. Yeah, seashells. Did we get to this one? Oh,
I think
yeah,
we did get that one. Yeah, we did.
did.
And then there's more. It's just Big Z. Yeah, there's apparently a new filing by Wayfarer Parties Re 806. Letter motion to compel Wayfarer Parties, unavailable on Court Listener, but maybe not on Pacer. I have seen it. I'm gonna wait till tomorrow to mess with that though, because it's a different subject entirely. And so
yeah,
it's like past 1 a.m, and I have to wake up in 6.5 hours for work. So I'm gonna have to pass on that one for tonight. But I will get to it. Don't worry.
We'll get to. I wanted to go live tonight because I haven't gone live on consecutive days in a long time, and this is my big chance. I just thought that it was going to be a lot more lighthearted than it was. It got me all like frazzled.
Yeah, because I'm mad, dude. I'm not like mad like, other times that I've been mad, but like I'm mad like I don't understand this, and I think it's insane.
I'll state this too. I will fully admit that I am a little biased because I am favoring that. Well, I mean, I favor Baldoni's legal arguments.
Oh yeah, see, I don't favor Baldoni.
Well. I would prefer that 47-1 shouldn't apply in this case. And so I'm kind of reading this from the perspective of an attorney that just had this dropped on my desk, and now I got to find some way to attack it. And hey, their arguments have merit and they're problematic, and we got to find some kind of a way out. That's kind of the way that I'm looking at it right now, which is why I'm like kind of all over the place. It's really difficult to be objective with this case, as hard as I've tried. Over the course of,
I gave up on that. There's no objectivity in my reporting. I 100% believe Justin's side of things. I am not fucking with Blake's bullshit. So like, I don't know. I maintain though that the evidence of sexual harassment was obviously in my bank statements, and if she had only been able to subpoena them, she would be telling her story right now.
I'll tell you what, though. I mean, I'll be 100% honest. If there is merit to their legal arguments, I'll call it out. I'm telling you right now that there is. Yeah. They have a pretty decent argument that 47-1 should be ruled on now, that she shouldn't have to prove anything, that she's got a decent chance of prevailing.
That is fucking nuts, bro.
I'm just saying, I'm throwing that caveat out there.
Imagine this lady, like this law that's supposed to, like I said earlier, protect normal people. This lady is taking over this law and saying, like, basically, before I prove anything or show that I'm telling the truth at all, give me hundreds of millions of dollars. It'll be fine. It'll be fine.
It's disastrous.
What the hell, dude?
Just wait to see, because I imagine that they're going to reply to this maybe tomorrow, the day after, fairly quickly. But they got it addressed.
They did their response, right? So, like, are they going to do that again?
I don't know what the judge is going to allow them to do, but they should be able to file a response to that, especially if it's misrepresentative. Well, here's the thing.
3 different depositions going on tomorrow, though.
So maybe not tomorrow. I don't know when Lyman is going to rule on this, but if there's a material misrepresentation that they agree to California law as to Lively's claims, that needs to be addressed before Lyman makes a ruling, lest he make a determination based on a material misrepresentation.
Well, he likes to do
that. One. Yeah.
Saying. But like,
there's actual misrepresentations, and then there's imagined ones, and we've seen both.
Yep, that's for sure.
So, anyway, that's all I got for you folks for tonight. But we will see and monitor what happens with this. I'm going to be doing some Murdaugh stuff because Cassidy turned me on to the fact about there's an appeal going on with with Alex Murdaugh.
Who the hell's Robert Murdaugh?
I know, like, I don't know. Yeah, I'm going to be covering some stuff on that this week, time permitting, and obviously some of this lively stuff. Anyway, you need to get your rest, young lady.
I'm getting older by the day, bro.
You know what would have really helped if I had a beverage, like an alcoholic one? Tonight would have been the night to have like one of those mega pint glasses that I have.
I thought you were teabagging.
No, I didn't teabag today.
I thought you teabagged every day.
No, well, usually around noon. I'll have like a little vanilla magic energy tea or whatever.
Your afternoon teabagging?
Afternoon teabagging with a little bit of honey.
Okay. All right. I noticed in your comments on the video the other day after we, did our live and I had mentioned the teabagging right in the beginning, they were like, guys, everybody's trying to tell us, guys, that's not what teabagging means. I was like, yeah, that's why I said it. That's not why I said that. Okay.
Just trust me if there's any reference like that.
The difference between your comment section and mine is so innocent. Like your ears are like, oh, guys, no, that's not what that means. And mine are like, oh, my God, I know exactly what you're doing.
Anything like that, Lauren knows exactly what she's saying. Just trust me. She does.
All right, I got to go to bed, man.
All right, folks. Y'all get some rest. Good night to you.
Bye.
Bye-bye.